the causes of action that on or about February 1, 2011 the attorneys Rourke and Theodore commenced, and presently continue an attorney-client relationship with an entity known as Grandview Palace Condominium of New York, a 396-unit condominium complex located in the hamlet of Loch Sheldrake, town of Fallsburg, Sullivan County, New York. The 396-unit complex burned down and 2,000 unit owners lost everything, counterclaimant Peter Perrineau being one of them. At all times attorneys Rourke and Theodore held themselves out as competent in the area of law dealing with the legal matter for which Grandview retained the services of attorneys. Counterclaimant Peter Perrineau / Grandview and attorneys Rourke and Theodore acted under an attorney/client relationship in which attorneys undertook to represent Grandview. Counterclaimant Peter Perrineau owned and lived in a unit at Grandview Palace Condominium Complex and therefore a client of attorneys. Attorneys Rourke and Theodore were required to exercise the same legal skill as a reasonably competent attorney and use reasonable care in determining and implementing a strategy to be followed to achieve Grandview's best legal goals, mainly being the payment of $74 million in insurance proceeds. As a fiduciary of Grandview, attorneys Rourke and Theodore are obligated to treat all information relating to Grandview as confidential and to zealously represent Grandview's best interests within the bounds of the law, including the disclosure of any conflicts of interest that might impair attorneys' abilities to represent Grandview. In the course of handling the legal matter for Grandview, attorneys Rourke and Theodore negligently failed to act with the degree of competence generally possessed by attorneys in the state of New York, who handle legal matters similar to attorneys Rourke and Theodore. Grandview paid attorneys Rourke and Theodore large sums of money for the sole purpose of representing Grandview in legal matters. Grandview affirms that attorneys Rourke and Theodore were negligent and/or committed legal malpractice and breached fiduciary duties to Grandview. Attorneys have wrongfully advised, directed, enforced and have violated many articles of the HOA bylaws, First Amendment right, New York state laws and New York Lawyers Code of Professional Responsibility, in the following regard, by failing to correctly and properly explain to Grandview that buying units using Grandview HOA funds, and investing in the risky real estate market are against the bylaws and not a delegated action, according to the bylaws Article 8 Section 2, costing Grandview to suffer a loss of $100,000. Article 8 Section 2 states, consent of unit owners to purchase or lease by Board of Managers. The Board of Managers shall not purchase any unit without the prior approval of 75% in number and in common interest of unit owners. Attorneys Rourke and Theodore did in fact, planned, organized, implemented and executed the wrongful act of purchasing units at the Sullivan County, New York tax foreclosure auction, and even rigged the bidding to aggressively and wrongfully acquire these units, just so to profit. Upon information and belief, attorneys Rourke and Theodore demanded the payment of $50,000 in legal fees for overseeing this illegal act and wasting Grandview's money. Attorneys refused to show an itemized invoice explaining these fees. Grandview do hereby respectfully requests the court rule in favor of Grandview and order the attorneys Rourke and Theodore to reimburse the $100,000 that was lost due to attorneys' bad advice and illegal actions, plus all cost, fees, interest and penalties associated with this wrongful act. By wrongfully advising Grandview and not alerting Grandview that falsification and misrepresentation of the insurance application will render the entire policies null and void. By denying access to fire investigator and tampering with evidence, attorneys Rourke and Theodore are responsible for the denial of $74 million in insurance proceeds, due to their attorney negligence, misrepresentation, improper actions, bad advised, misconduct, profiteering, and greed. Attorneys Rourke and Theodore made the wrong decision to refuse access to the boiler room, the source of the fire, to insurance investigators, and to tamper with evidence by, in fact, removing evidence from the crime scene before it could be properly investigated. Hindering the investigation and evidence tampering are alleged in the insurance company's denial of claim lawsuit. By failing to preserve the confidence and secrets of their client and violating privilege when attorneys Rourke and Theodore publicly admitted that evidence were removed from the fire crime scene, especially after knowing that a whistleblower, working with the insurance companies, was present in the audience. Attorneys Rourke and Theodore are working against the best interest of Grandview and do not want us to collect our settlement. Grandview do hereby respectfully requests the court to rule in favor of Grandview and order attorneys Rourke, Theodore and the law firm of Rourke, Fine and Janices, and its successor Rourke, Fine, LLP to pay the cost of Grandview insurance policies totaling $74 million, plus all cost, fees, interests and penalties associated with these wrongful acts, to be paid in an account administered by the courts and counterclaimant Peter Perrineau to rebuild Grandview Palace. Mishandling and commingling of client funds and failure to produce financial records. By allowing 2,000 people to continue to live in a death trap of a buildings, without proper certificate of occupancy, inspection and fire protection, endangering their lives and welfare, and thereby did in fact burn down. By wrongfully advising HOA not to bring building up to code, and this very bad advised lead to a fire that destroyed everything. By demanding an illegal maintenance fee of $90 per month, when the property does not have a proper certificate of occupancy and nothing to maintain. By demanding maintenance fees without a budget and a proper explanation of the spending of funds, against Article 6 Section 1 of the bylaws. By wrongfully threatening to put liens on unit owners in good standing without proper due process of law. By illegally voted HOA-owned units to stay in power against the bylaws, Article 2 Section 2, I. By withholding and denying access to fire insurance policies to unit owners to settle their private insurance claims, especially when it is most needed after the fire, and then charging Grandview to see the policies. By wrongfully preventing and blocking an attempt to legally remove the Board of Manager against Article 4 Section 3. By controlling and managing every aspect of HOA accounts, receivables, payables, all banking, telephone inquiries, bookkeeping, answering phone calls, etc. To find out their arrears, HOA members must go through attorneys. By taking advantage and abusing the frail, octogenarian Board of Managers. By wrongfully withholding financial records and failed to produce such records upon many demands. Advising the HOA not to pay school and property taxes, and jeopardizing Grandview property from being in default of taxes. By wrongfully denying, suppressing and infringing upon Grandview's unit owners' voting and free speech rights. By failing to maintain the integrity and competency of the legal profession in dealing with Grandview. By failing to represent the client, Grandview competently. Overzealously represents Grandview above, beyond, and outside the bounds of the law. By failing to avoid even the appearance of professional impropriety. The appearance of wrongdoing is worse than the act itself. by holding themselves out as attorneys for Grandview but does not represent the best interest of Grandview. By taking large sums of monies without any accounting and proper invoicing therefore. By making a secret deal to sell Ho a vehicle to attorney Theodore's father for about $9,000 and counterclaimant Peter Perrineau, by showing up to the auction increased the bid up to $22,000. By intentionally committed dishonest acts and by not fulfilling legal or contractual obligations, misleading the 396 members of Grandview. By violating basic standards of honesty in dealing with Grandview and by failing to provide Grandview with the minimum standard of care. Counterclaimant Peter Perrineau has demonstrated that attorney's lawsuit is an action against public petitioning and participation. This frivolous SLAPP lawsuit was commenced and continued without a substantial basis in fact and law, and could not be supported by a substantial argument for the extension, modification, or reversal of existing law. Attorney's lawsuit lacks the cause of action, for the document in question is an absolute privilege document, which makes counterclaimant immune from libel. Pro Southeast defendant respectfully seeks a judgment in favor of counterclaimant Peter Perrineau to recover costs and attorney's fees in the sum of $28,000. In addition, to the negligence and/or malpractice committed by attorneys Rourke and Theodore as mentioned in the above paragraphs, attorneys fraudulently and recklessly induced Grandview to pay them large sums of money by making representations regarding legal matters, which were untrue. Grandview requests that all legal fees, especially unearned and wrongfully billed, in the sum of $150,000 to be returned to Grandview. As a direct and proximate result of attorneys Rourke and Theodore negligence and/or malpractice and fraudulent inducement, Grandview sustained actual damages of $74 million, and as stated above. Counterclaimant requests the court rule in favor of counterclaimant Peter Perrineau and Grandview and rule for a judgment from attorneys Rourke and Theodore in the amount of $74 million in compensatory damages and as stated above, together with pre-judgment and post-judgment interests and all cost accrued herein to be placed in an account administered by the courts and Peter Perrineau to rebuild Grandview Palace. Respectfully submitted,